That's the thinking. Good evening. My name is John Milburn, and this is Laws 11059 Statutory Interpretation. We're into week 4 of 2018 term 3. Thank you. We have so many people online. That's excellent to have this great turnout. We've had some lively discussion. I think some amusing cartoons as well before starting to record this session. So those of you that have done some background work in terms of Bell and Townsend, I'm told by John, thank you John, that it's not in Note Up from section 4, but it is in Ostley. And I would encourage you to, in the live session, ask any questions, and you can do that by unmuting your microphone or asking through the chat facility. This week, I'm keen to ensure that you're making positive steps to having a system that works for you. It's something that you need for your assessment, and it's something that you need for general practice and certainly the practice in law. So has everyone started to create something of a template that they use for creating a workable way of using statutory interpretation in a practical sense? So you'll need this for your second assessment piece. Just a yes or no, just to get you started. Have you built a template now to get something ready for the second assessment? So we're getting a couple of yeses, a few yeses, that's good. All I'm ready after at this stage is whether you've felt you've created the framework, the platform, and the idea is to do that now. And if you haven't already done so, I'd ask that you do that now, because as you come across something that you think is interesting, some article, some flowchart, some diagram, some statutory provisions or a case, you want to have somewhere to pop these things so that they make sense for you at a later time. So if you like, the template is, the idea of the template now for you would be to use it as, in the meantime, as a repository, and from that you can draw information that will assist you in preparing a response for your second assessment. So Gary's got an Excel spreadsheet. That's a very good idea. Others might use a Word document, and you can be creative in this regard. So I'm asking you to look ahead and understand the assessment that you are aware of already and start to work towards that. Please do not leave it to the last moment. It's something that you can build progressively. All right. This week we're dealing with context and purpose. So it is, if you like, the modern approach to statutory interpretation. We usually start, of course, with the text, don't we? We look at the actual words, but we do that within the broader context. Now, if we're looking at words in a statute, what do you think I mean by the term context? The broader context. Can anyone give me some idea of the extent to which this context exists?
From what I was reading earlier, the broader concept of context within the legislation was that it needs to be taken as a whole with every word around it, basically.
Absolutely. So when you read sections within an act, you must do so within the context of the entire act. So that is an important function. Do we go further than that, potentially, in exploring the context? And if so, where?
You could look at the explanatory memoranda.
Yes, explanatory memoranda or explanatory note.
Yep.
Thank you very much. Shona says, looking to fix the meaning of the words together. Tammy says the surrounding words, the existing state of the law, if you like, the mischief. Yes. Extrinsic material, says Megan. Second reading speech, says John, which is an example, a very important example of extrinsic materials. So this could start to drive you a little crazy, couldn't it? Because if you think about this from within the, if I'll use the word context again, within the context of legal practice, what I'm telling you may mean that you feel that you're going to have to spend hour upon hour upon hour, potentially, to answer a simple question. So you need to regulate your ability to consider the context against what it is that you're seeking to achieve and the question that's being asked of you. So, for example, if someone says, what's the maximum penalty for stealing under the criminal code, then you might look to the maximum penalty provision, and it's pretty simple. Read that part and provide the answer. The question then is, for that particular question, do you really need to go beyond and look at the entire act and read the section that relates to, I don't know, stalking? Your employer, if you're on hourly rates, may not be too keen for you to put in a timesheet 30 hours to answer a question of that nature. So do you understand perhaps the dilemma and the trade-off, the compromise that is inherent in the process of statutory interpretation? Now, having said this is the way we do things, and then provided you with a good reason to say, don't do that, you might justifiably be a little confused at this stage. But we'll work through these issues. But I'm really suggesting that you need to have something which will assist you in the mindset so that you know how to look at material within context relatively quickly, if that's the case. Now, were there any questions as a result of that confusing comment? Yes, Lachlan.
Not really a question, but sort of a statement that could be interpreted as a question. You remember how I was talking about Lincoln, my friend that was in your class for this last term or whenever it was? He was telling me that probably, and this would be due to context, I would imagine, that magistrates and judges almost never actually do impose a maximum sentence. I would imagine that that is entirely based on context.
Yes, that's true. It is very rare for the maximum sentence to be imposed. Sometimes the maximum sentence is also the minimum sentence, such as murder, but that's pretty rare. But yes, that is correct. So when you look at that, and that's a very good example of what I've just said. So whilst you might be able to say in a very simple way, this is what the statute says, the maximum penalty is 14 years imprisonment, you're right. If you answer that question within the context and give a more complete answer, then you need to look more widely. So in a way, what I'm trying to describe, perhaps inelegantly, is this basic distinction between statutory interpretation, which is based on literal reading, the literal rule, black letter law, this is what it says, I'm not going to think about anything else, and considering the wider context. So if the question is simply, what is the maximum penalty? 14 years. But if the question is, what is the maximum penalty but what am I likely to get as a sentence? That's when you need to look more widely and consider.
I have a good and recent example as well. You guys might be familiar with, there was a case down south somewhere of a paramedic that got severely assaulted by two women. And a lot of the paramedics and ambulance workers and whatnot went on strike purely because these two, there's a common sort of blanket law that anyone that assaults a paramedic has to serve a minimum time of 6 months in jail or something like that. And there were almost riots from these health services workers about the fact that these two women, under the context that this magistrate came to put together, where he basically said to the the paramedic that was assaulted, he said, I'm really sorry for what you've been through, but under the context of what these ladies' upbringings have been and the levels of intoxication and everything, I can't actually make what is known as common law or whatever it was happen.
Yeah, so I understand, and thank you very much for that. That's a good analogy. Amy says, yeah, that's wrong. Tuna says sentencing factors come into it. That's a really good point. You read my mind. John says mandatory minimum sentences introduced after that case that you've referred to, Lachlan. And yeah, really quite horrid. Okay, so when we look at that simple scenario of maximum penalty, it might be very easy to read, but we need to consider more broadly. So in that instance, just picking up on what Tuna said, I hope you don't mind that I use that shortened version of your name, Tuna. I think we said that's fine. All right. Sentencing principles will have a part to play in that. So if you're reading those words, do so within the context of sentencing principles. Now, where would you need to look to get a better idea of what's meant by that term within the broader context of sentencing principles? Trick questions. Sentencing Act. Yes, John. Thank you. In Queensland, what do we call the Sentencing Act? But yeah, that's exactly the answer I was looking for. Thank you. Does anyone know? It's the Penalties and Sentences Act, which I think is 1992. So when you read something in the Criminal Code about the maximum penalty, if you're considering the broader context, not only are you considering potentially parts of the Act itself, explanatory notes, explanatory memorandum, second reading speeches, and extrinsic materials in the form of secondary sources of law, such as textbooks, but you're also considering other pieces of legislation that may have a direct bearing on what's meant by that particular term. So in Queensland, the Penalties and Sentences Act. John says in Victoria, it's a Sentencing Act. And that contains 10 overarching principles. Punishment is the first principle. Yes, so there's similar legislation around different states. So as part of your, if you like, extra homework this week, please look at the Penalties and Sentences Act or the counterpart in the state or territory where you intend to, where you live, what's of interest to you, and get a feel for what's meant by this broader context in relation to sentencing. Beyond that, you can go further and look at Law Reform Commission reports, for example, or you can look at the bill in relation to the introduction of the Sentencing Act to give a better idea, or to get a better idea of what's meant by these terms. So if you only look at the phrase or the word within an act, you don't go broader, you don't consider broader aspects, you can lead yourself into error, or you can be accused of giving too simplistic an answer. And the hard part is trying to balance these things. I don't want you to spend a week looking at something that someone would expect you to complete within 20 minutes. And I know you're going to say, how do I know? That will come with some experience and a bit of common sense. But you need to, at this stage of your studies, consider things in a very broad manner so that you're not falling into the trap of saying, that's easy, I know what the answer is, and then move on. Because there are other aspects to interpreting legislation that you'll need to consider. That's where, for example, the flowchart in Michelle Sanson's book is useful, but, and I say this respectfully, I think that you can do better for yourself. So I've given you an example of the introduction of the Penalties and Sentences Act regime, which probably doesn't fit neatly within the flowchart. If you apply the flowchart to that simple phrase of what's the maximum penalty, I'm not sure it would lead you to the Penalties and Sentences Act. So you might have to create something for yourself that gives you these clues, these hints, this method of thinking, this methodology of thinking that does give you a better chance of picking up on other issues that might be relevant. I'm doing a lot of talking, but I hope that makes sense. Yes, Lachlan?
In terms of the Sentencing Act, I'm very vaguely familiar with it. I know that there are maximum sentences, but are there minimum sentences? And would you consider an approach to considering them to be unreasonable?
Yes, there are. And John, you provided the right answer, the answer I was looking for in relation to Lachlan's question about, are there minimum sentences? Would you like to explain that a bit more, or am I putting you on the spot?
I know there are for some offences. I am aware of that, but what I more mean is is there like a blanket minimum for, not blanket minimum for everything? Well,
No.
yeah, like is there individual sort of...
Well, I think we get it, Lachlan. We'll just
Yeah.
give John an opportunity. Thank you, John.
I don't know whether you can hear me. Can you hear me, John? Yeah, okay. It depends on the particular offence as to what sentencing regime applies. So some offences have a minimum mandatory sentences, and
You've cut out for a sec there,
Just
John.
lost you there for a bit, John.
okay. So can you hear me now?
Yep.
Got me back? Okay. So a minimum mandatory sentence might be like 1 month's imprisonment, but minimum mandatory sentences are really controversial in the legal, the legal fraternity, because it's often argued that it takes away the tribunal, the magistrate or the judge's discretion, or the decision-making process.
I sort of see what you mean there, because one of the things that we were learning about, I'm not sure which class it was between this contract and intro, but it was about how the media can ruin the public's trust in the judicial system. So it might pertain to that as to why they're a bad thing.
For instance, as an example, up until not that long ago, within the last 5 years, if you were found guilty of a second offence of driving whilst disqualified in Victoria, there was a minimum mandatory sentence applied of 1 month's imprisonment. So regardless of who you were or what the circumstances were, magistrates and judges had no alternative but to send you to jail for a minimum of 1 month. And unfortunately, a lot of people were caught up in that, and a lot of good people in prison, because they, just a bad decision, actually impact upon anybody.
Sorry, we're sort of half getting that, John, or at least I am.
Just starting to drop out there. Lachlan, I might just perhaps make a comment here, and that is, yes, I agree totally with what you're saying there, John, and good question, Lachlan. Bear in mind, of course, that then begs the question, what do we mean by prison? And must
suspended sentences
someone to prison. It may mean actual term of imprisonment. It might be suspended term of imprisonment. It might be parole, or it might be an intensive correction order, for example. So there are, or home detention, as Gareth said. So even within that context of the statement that's made, there may be some wriggle room to look at. So really the purpose, and I don't want to digress too much into criminal law now, but what I'm trying to emphasise tonight is that this concept of context is a floating thing, and it depends on the circumstances, but you just need to be aware of it and make an assessment as to how far you go in order to consider the context. How much reading do you do? So when we talk about context, almost always we'll talk about it within the phrase context and purpose. So when we talk about purpose, what we're really talking about is the intent of Parliament, what the interpretation would best achieve the purpose or the object of the Act. So that's the statutory approach, which is now the common approach. The section that you might look at there, and I've mentioned previously, is section 15AA of the Commonwealth Act, Interpretation Act, which requires you to consider the interpretation that would best achieve that purpose or object of the Act. That is, that which is preferred to each other interpretation. In Queensland, we have something similar, but it's not the same. And we have what's called the preferred construction approach, which is still used in states other than Queensland. So there are slight differences in what we talk about between different pieces of legislation when we're talking about the purpose. So look out for phrases such as that which would best achieve the purpose, as opposed to the preferred construction terminology. Subtle differences, but keep an eye out for those. Now, when we're talking about the general principles of statutory interpretation, I mentioned that we need to look at the text first, and the court must consider the text itself. It must rely upon the clear meaning, if there is one, in order to make its decision about the object. Very important case for your assessment, and generally, as mentioned earlier, is Project Blue Sky against ABA. Now, there's a quote at paragraph 69 where the court says, ordinarily, the meaning, that is the legal meaning, will correspond with the grammatical meaning of the provision, but not always. The context of the words, the consequences of a literal or grammatical construction, the purpose of the statute, or the canons of construction may require the words of a legislative provision to be read in a way that does not correspond with the literal or grammatical meaning. So that's a key paragraph within that case, which goes to describe the nature of how we interpret legislation. Let's just break that down a bit. So ordinarily the meaning, the legal meaning, will correspond with the grammatical meaning of a provision. So we see from that that the courts draw a distinction between grammatical meaning and legal meaning. Often they're the same, but not necessarily the same. Now,
sorry, John, question. Would that go to say that if you were good enough, linguistically speaking, you could misappropriate the context and have it stick?
I don't understand the question, sorry.
What I'm saying is basically, could you then, if it's sort of hard to word it the way that, what I'm saying is basically, you know how there's the whole theory behind if you've got a really good lawyer, they could get you off anything, so to speak. What I'm saying is more, is that a realistic overview of that, is that in some circumstances, context can be misappropriated in a way that, in I guess my mind, sort of justifies how some of those cases pan out.
Well, what I can certainly, yeah, all right. So I think I get the idea of what you're asking, and certainly yes. One of the tools that lawyers should always use is asking those critical questions about what does this actually mean? Is there another way of looking at this? How can I use this word or this approach to my client's advantage? So, you know, it's similar to the approach adopted by defence lawyers in criminal law cases, where what you're really trying to do is just stop the prosecution being successful. Some of the ways of doing that might be to prove through evidence that you introduce the contrary situation, or it might be simply to challenge the evidence which is presented by asking the jury or the magistrate to answer this simple question, and that is there a view of the facts which is consistent with my client's innocence? And if there is, then there's reasonable doubt. In other words, you're looking at, that's a parallel situation where you're asking this question, is there another way of looking at things? And that's what we really do in statutory interpretation. So we're saying, okay, this is the legal, this is the grammatical meaning, but is it the legal meaning of the terms? Now, has anyone done or is doing contract law? Because I'm looking for an example here of a word which has a difference in grammatical meaning as opposed to legal meaning. And this will best illustrate this phrase from Project Blue Sky. All right, so a few people are doing contract law. Can anyone tell me, so if someone is not doing contract law, what do you understand by the word consideration? If someone's providing consideration, what does that mean? Those of you not doing contract law. Yes, Gary?
My interpretation of that would be that they are taking time to digest and divulge the information that's being presented to them. So
yes,
they're taking something into consideration.
That's right. They're taking it into account,
yep.
Or they're being considerate. That's kind of the grammatical meaning. So that's a really good approach. So thank you very much for that, Gary. Now, those of you that are studying contract law, can you tell me what consideration means as a legal meaning? Anyone wish to volunteer?
Yes, a legal meaning, something for something.
Yes. So it is to provide an exchange of money, says Timothy, or it's to exchange some benefit or detriment for something provided by the other party. So that's different, isn't it, to what you'd normally think of, as Gary rightly explained, as its grammatical meaning. So sometimes there is a distinction between grammatical meaning and legal meaning. We know that because that's what it says in Project Blue Sky. The question I'm posing now for you is this. How are you going to build that into your flowchart? You've only got, for second assessment, you've got, what, 5 things? You know that you must take that into account, and you must consider that ordinarily the legal meaning corresponds with the grammatical meaning, but where is that going to fit in your thinking, in your analytical steps? You have to answer that for yourself. Let's move on. So going back to that quote, the court said ordinarily the two are the same, legal and grammatical, but not always. The context of the word, and here's the court gives us some dot points. It says what you've got to consider is this. When distinguishing between the legal and the grammatical meaning, the context of the words, the consequences of a literal or grammatical construction, the purpose of the statute, or the canons of construction, all of those things may require the words of the provision to be read in a way that does not correspond with the literal or grammatical meaning. Now, then you've got to ask yourself, so is the High Court saying that there's a way of looking at this where we don't even choose the literal or the grammatical meaning, we choose this legal meaning? Have a look at that paragraph. I'm sure you're dealing with that in your first assessment, and I want you to try and build into that concept into your second assessment. Does that make sense?
Sorry, John.
Yes, Gary.
Just a quick question. In paragraph 71 of Project Blue Sky, it's quoted as saying, furthermore, court construing a statutory provision must strive to give meaning to every word of the provision in the Commonwealth v. Baum, et cetera, to support the proposition that it was a known rule in the interpretation of statutes that such a sense is to be made upon the whole, as that no clause, sentence, or word shall prove superfluous, void, or insignificant if by any other construction that they may be useful and pertinent. Does that not add an element of literalism, or even in some form contradict paragraph as you described in paragraph 69?
Arguably, it's a very good point. It's very insightful. But I guess the court is really asking you to ensure that you make a preliminary assumption, and the preliminary assumption is that Parliament means something as a result of everything it writes. So don't assume necessarily that something is superfluous or redundant in the context. So you've got to read more broadly and assume that everything should be considered within that regard. All right, so thank you, Gary, for that. So the meaning of the text may require consideration of the context. We know that. We have to consider, amongst other things, the canons of construction. That's a phrase that's used in that paragraph. What do we mean by canons of construction? Anyone come across that? All right, so bear in mind, yep, so Timothy says fundamentals, yes. John says text, cases. I like fundamentals and cases because canons of construction are really common law principles, is another way of saying that. So during the course of statutory interpretation, we understand that there are some common law principles, some canons of construction that you must consider. So we always look to the statute first, that's the most important, but when you're considering the words within the statute, you may have to consider these canons of construction. So somehow you're going to have to build in canons of construction into your flow chart. Do you understand? So look at that paragraph and try to make sense of it in a way that works for you. I know I'm repeating myself, but it's important. Let's move on. So you need to consider the relevance of the provision. You need to consider the provision as a whole. We know all that. And we need to consider how these things are, yes, canons with one N rather than canons with two N's, correct. So we need to reconcile conflicting provisions. Sometimes it happens, and you need to have a system for working on that. So if you come across conflicting provisions, and Gary has given us, I think, a good thing to think about within the context of what was said in that case. But if you have that kind of anomaly within a statute, are there rules that apply to determine which one applies, is precedent over the other? Likewise, if you have different pieces of legislation with different words or words that appear to be in conflict with each other, how do you reconcile that? No answers, but just asking you to consider these things within the context of preparing this flowchart for yourself. So you need to consider the express statement of purpose within the statute. We know that. We have to be able to infer from the text or the structure what is meant by something, and perhaps refer to extrinsic materials. So apart from Project Blue Sky, you probably want to have a case or two that best illustrates some of the points that you wish to raise in each part of your flowchart and your analysis. So be mindful of trying to support any statement that you make about your flowchart, your methodology, with a reference to a section of an act and/or a case or two. So the starting point is the analysis of the act. Look at it as a whole, seek to determine what it intends to achieve, and then work on the interpretation from there. Now, another quote from Project Blue Sky. Yes, sorry. Yes, Lachlan.
I was just going to ask, for those of us, embarrassingly enough, who are still playing catch up, could you please give us a brief overview of Project Blue Sky?
Look, I won't just now, but what I might do is add something into Moodle in that regard. So, and the reason I'm saying that is that I'm so caught up with the tenets of it that sometimes I overlook the facts, sorry. But it was to do with the content of, and those that of you studying Project Blue Sky, you probably can answer much better than I can. But it was to do with, Lachlan, the content of Australian media content as opposed to overseas content. But I won't go into the facts of that more because otherwise I will get it wrong. Is anyone familiar enough with Project Blue Sky that they're willing to give us an overview of the facts in the case? Tuna says Project Blue Sky dominated by Section 122 and Section 160 of the Standard Content Act. Now, is there anyone wanting to give us an overview of the facts?
Essentially,
Yes,
my take on it is that there was a particular part of the legislation that stated that New Zealand was to be treated along the same lines for broadcasting as the Australian content. So that's my kind of take of it in a nutshell.
Thank you. So, sorry, thank you, Tammy. That's good. All right, so another quote from Project Blue Sky. Have a look at paragraph, or look at page 384, paragraph 78, and this is the authorised report, the CLR report. The duty of a court, and this is really important, the duty of a court is to give the words of a statutory provision the meaning that the legislature is taken to have intended them to have. So the important part about that is that when you're considering statutory interpretation, you must consider what legislature intended the words to have. And that begs a few questions. If you think about it, does that mean at the time? Does it mean something that will change in future? And on what is it based? So when you're talking about, say, the international nature of the facts in Project Blue Sky, are we talking about treaties? And Gareth raises a good point in relation to treaties. Delegated legislation and act that has been put in place is breached if it breached a treaty, was also in the act. Lachlan, Tuna says, question of whether it's mandatory or directory. Yep, so there's those aspects as well. And you need to consider whether it is mandatory or discretionary in some different ways. So the context then you can ascertain by looking to some degree internally, look to the Act itself, but then of course you need to consider the external context, which are all the surrounding circumstances. It may mean considering historical facts as well and going to the mischief, as was mentioned earlier. The presumption is against altering fundamental common law doctrines. So what do we mean by a common law doctrine? Can anyone give me an example of that?
So basic human rights. So
yes,
you know, I'd say right to life, etc.
Okay. Yes, absolutely. What about, for example, police not having the right to just go onto someone's private property without good reason? That would be another example, wouldn't it?
There's that, and there would also be things like, are you talking about things like, what are the wartime laws that say that everyone should have access to food and all that stuff?
Yeah, I suppose
what's the name of those? What's the name of those that are, I can't remember it, but they were like
rationing. Are you talking?
No, it's like the laws that were in, like, it's like global law that's in place to protect people in general, really. That's sort of like a UN style law, but just
so
like
basic human rights you're talking about?
Yeah, I think so.
Okay.
It comes under that.
Yep, sure. So look, another one might be, so if we're just talking about basic human rights and the fact that legislation must be read consistent with the preservation of those basic human rights, what about, for example, the right to a fair trial? So we'd say, yes, that's a basic right. So if you're interpreting legislation, you need to consider that unless there are specific words, express words to the contrary, then everyone has a right to a fair trial.
Is that a universally recognised sort of legislation or statute, so to speak?
It's in the Constitution.
Is it in everyone's constitution, though?
Yeah. I'm not sure about the constitution of...
Not every country has a constitution. Not every country has a constitution.
Yeah, fair point. Yeah, it was the Geneva Convention that I was referring to before.
All right, and I think someone picked up on that, so thank you. All right, so when you're interpreting legislation, when you're preparing your flowchart, what I'm suggesting to you is that somehow you have to check to ensure that any interpretation that you make of legislation is consistent with these fundamental common law doctrines or rights. Principle of legality, What that means is you've got to understand what we mean by these common law doctrines, and then you've got to come across and catalogue some examples of it. For example, I've mentioned, well, what another one might be a general presumption that law is not to operate retrospectively. So that's a common law doctrine, and anything that you read in a legislation should be interpreted so as not to breach that common law doctrine unless it's specifically stated to the contrary. Does that make sense? Right, so as you're reading your material, you need to start building some of these things into your catalogue of different principles. Another might be, if it's a penal provision, then the question might be, is this to be determined by reference to the standard of beyond reasonable doubt or by reference to the balance of probabilities?
I have another question in terms of all that. Like, there was that case on the news that was cross-jurisdiction within the last 2 weeks, and they've been extraditing the people that were responsible for it between Queensland and New South Wales because it happened in Tweed Heads and Surfers Paradise and whatnot. How much authority does anyone have in regards to extradition and that sort of thing, and enforcing any kind of anything, really?
Yeah, do you think that's really a question for statutory interpretation, though? Look, I mean, I'm interested in it, and I'm happy to go there, but I'm concerned about digressing too much.
Yeah, sorry, I tend to do that.
You can absolutely ask the question, but we need to try and build it into the context of statutory interpretation. So I'm open to your ideas, but just looking for that link. If you don't.
I was more sort of seeing, like, how far does our statute reach, so to speak?
Yeah, I'm not sure I can answer that. It's a bit broad, that question. Sorry.
Like, at what point does the statute become invalid? Like, you know how in international waters, so to speak.
Again, that's probably a fairly broad question. So, are you talking about whether it's the legislation is constitutionally
I'll give you. Sorry, John.
Yes,
I'll just jump in there, mate. Mate, I'll give you a case to read. It's actually in page 280. It'll probably be able to help you out, mate. Case exercise 12.1. It's CPCF v Minister for Immigration and Border Protection. Long story short, basically it was Australian intercepted a CEV, suspected illegal entry vessel, in international waters, but was extraterritorial. It was extraterritorial designated legislation under Australian legislation. They then moved them to India, where they couldn't offload them there. They've then shipped them to Christmas Island. If you have a read of that, mate, it goes into a lot of issues surrounding extraterritoriality and the applicability of legislation and application of certain acts within, for example, the Maritime Powers Act, how it conflicts with the Border Protection Act, etc.
Thank you, Gary. That's very good. Excellent. Thank you. All right. So coming back to our Queensland Act, have a look at sections 14, 14A and 14B, which are critically important to the process of interpreting legislation, and in particular to creating some structure to the way in which you answer questions. Make sure that you have catalogued things that relate to some of the specific sections in Part 8 of the Act. So those sections were 14, 14A and 14B of the Act's Interpretation Act. So you're going to have to build those in somewhere to your flowchart, and then look at and identify the important sections that you think might be relevant to your process in Part 8 of the Act. So, for example, 32CA, which deals with may and must. All right, so there are some of the things that you might consider. Now, last week we talked about the Statutory Instruments Act, so do have a look at that. It's only a short piece of legislation, and for example, look at the way in which statutory instruments can be broadly construed as meaning a whole range of things. So today, for example, I was involved in a case to do with construction and the way in which certain documents in relation to the QBCC are actually statutory instruments, and it's very broadly defined. So do have a look at Section 7, for example, of the Statutory Instruments Act, and you'll see that when we talk about statutory instruments, it's a very broad sphere. And if they're then statutory instruments, for example, by way of regulation, you need to consider how to interpret those as part of your overall process. So, and John asked a good question. If you're in another jurisdiction, may you substitute your own Home Jurisdictions Act? Yes, absolutely. I really encourage this. What I want you to do is have something that works for you. And if that means using your own state or territory, please do so, and I'll do the extra research if I need to answer the questions. If you have a question that is specific to Queensland, then by all means do that, use the Queensland Act. But generally speaking, I will always ask that you please adapt it to your own area where possible. All right, so have a look at the Statutory Instruments Act and have a look at sections 14 and 15 of the Act in that regard as well. So what I'm really saying is that subordinate legislation is important, and you need to build that into your process as well. Now, sometimes one of the important extrinsic materials that we use are materials such as dictionaries. So please consider that, and generally secondary sources of the law such as textbook. So you'll need to build that into your process as well. Now, one thing I wanted to do tonight, we're running out of time, but we might do this next week, is I wanted to look at the question that I set as the take-home paper last year, which, for those of you that have looked at it, was all about interpreting certain parts of the Work Health and Safety Act 2011 and the Work Health and Safety Regulation 2011. So may I just have a quick poll? Has anyone both read and considered to some degree the question that I set as the take-home paper last term? No. I think I've uploaded it. Not yet. Okay. I know you're very busy, but I'm going to ask a favour, and that is, can you please look at that question, try to find or source the Act, the regulation, and start to work your way through that question, because what I'd like to do is use that as, if you like, a template, a guide to how you might answer questions of this nature. I think it's important we do it now because it will help you directly for your second assessment piece, and of course it will very much help you for your take-home paper. So let's start doing that. Look at the Work Health and Safety Regulation at the Act, look at the question, start to formulate some answers for yourself so that we can discuss that next week, and over the next few weeks we'll probably come back to it a few times. It'll be a useful exercise. All right, so I won't start on that now, but I'll give you that homework to do. And if you can't find the material, you can't find the legislation, please let us know. If you have a question, generally speaking, please ask through Q&A so that I can provide a response, or just as importantly, as we saw with Gary tonight, thank you, and John and others, please consider responding to others' requests. So if you ask through Q&A, you'll have more people looking at the question than just me. All right, now are there any questions, comments in relation to what we've covered tonight? I know I haven't followed the text, but I'm sure that you can read the text just as intelligently as I can or explain it to you. I'm not here to paraphrase the textbook to you, for you. Any questions, comments, or all good? All right. So have a look at that homework that I've mentioned. We're not going to see you next week. Next week is the university break. So we'll see you here in 2 weeks' time. Okay, I'll wrap it up for this evening. All the best, and we'll see you in 2 weeks. Bye then.